Mhm.
I was looking in the record for evidence that these various decisions, Reich's reactions to the plaintiff and how he treated her, I was looking for evidence that suggested that all of this was motivated because she was a woman or because she was age 57 or 56, whatever she was. And it seems to me what comes through at best is that she maybe wanted to favor he wanted to favor his friend Sealing, but not that he was motivated because of gender or age. And there are a lot of indicators that those two factors really didn't permeate this workplace. What do you have on the evidence on that?
Sure, Your Honor. As we set
Causation
out
I'm looking at now, motivation, causation, that type of thing.
Sure. And admittedly, Your Honor, this is not a direct evidence case. Brian Reich was not so foolish as to
I understand, but
announce
if you have a perfectly
Excuse me, counsel, Judge Niemeyer is trying to ask a question.
I'm sorry.
I was asking if you have a perfectly clean workplace where there is no terms and conditions of employment, no harassment employment based on age or based on gender, it seems to me ultimately the burden, as Supreme Court has said, ultimately the burden's on you to show intentional discrimination based on either sex or gender or age. And my review of the record looks like there was a lot of discussions about Reich's relationship with this particular employee. Maybe they didn't like each other. He did have other women regional managers. The company had 5 regional women managers and 4 males. And there weren't discussions or inferences or attitudes based on that. The question is this case really about the battle at higher levels in corporations for positions based on personal relationships, or is this motivated by gender or age? And that's, to me, sort of fundamental in this case. And I'd be happy to have you give some of the best evidence that you think shows that the motivation for moving her into this new job was based because she was a woman or because she was 57.
Your Honor, I noticed that my time is up on argument. May I respond?
Yeah, if it's okay with Judge Wilkins.
Of course you may respond.
Okay, I just wanted to make sure. So we have adduced a lot of evidence from other women employed at Tactile that falls into a couple of categories. One is consistent exclusion of the female employees from business meetings, training opportunities to be visible to other decision makers within Tactile. And we compiled and cited much of that evidence in our brief, although at the moment I'm having trouble putting my hands on exactly where, here we go. So JA 694 through 95, JA 1344 to 45, JA 1163 to 65, and 88 to 102. So there was also...
Counsel, that is helpful, but could you describe it? Because I think that was a fair question.
Sure.
You told us one is this respect with women in general, that there has been some sort of evidence, a lot of evidence, you say, about inequality in opportunity. Is that what you would say?
Correct. So
all right, and Judge Niemeyer mentioned that there were 3 people that had the same title, 3 women that had this same title. I thought I read somewhere in the brief that they were given the smallest areas, but you tell us what the evidence is.
Correct, Your Honor. The women employees, with the exception of Jackie Gorham, who I will take as a separate issue here in a second, with the exception of Jackie Gorham, the women regional sales managers had the smallest regions and were far underpaid when compared to the men on salary basis. They were also excluded from meetings in which Mr. Reish's male direct reports were included, including meetings at which business decisions were made, strategic initiatives were decided. And then the men, sometimes Reish would have Sealing and Ferkenhoff, the men that directly reported to him, then go tell their female colleagues or direct their female colleagues about how they were going to implement these particular strategies or how they were going to do certain things. There is also testimony that women were not included in training at Tactile, particularly in opportunities to provide training to younger employees and to be viewed as leaders within the company in that respect. And in fact, Tactile's lead investigator, when Tactile was investigating my client's complaint to HR, Tactile's lead investigator acknowledged that one of the reasons that she had been hired originally at Tactile was because it had issues with Brian Reish being left free to favor Sealing and Ferkenhoff in quota assignment and other.
Counsel, you say that, but it was Mr. Reish. If he was, I thought he created the Mid-Atlantic region, and I thought he made the plaintiff the manager of it. And if he did those things, how is that discriminatory when you actually put a woman in a managerial position over what seems to me a pretty important division? But the other question I have, and it's sort of related to what Judge Niemeyer was mentioning, and that is companies like this are very often into profitability. They're not into discrimination as much as why would they want to discriminate against someone who is a successful and profitable sale manager? I mean, it at least raises a question in my mind, because these companies, the bottom line, they're all about money. They're all about profitability. They're not, and if they're not into discrimination, and if someone is being successful and assisting the bottom line, that's the big deal for them. And so they have these quotas and views of retention and views of growth in sales. And all of that is just related to the basic enterprise of making money, which makes everybody happy. If the company is profitable, everybody goes home happy. And if the company is not profitable, people get grumpy. So why is this discrimination rather than just trying to make some very practical decisions about the company's bottom line? And why would he make her a sales manager of an important region if he were out to discriminate against women?
Your Honor, and once again, I want to be mindful of the time. May I respond?
Yeah, I would certainly always.
When we have a question, you can respond.
Okay. I just want to be mindful that I am past my time. First of all, we disagree with the assessment that you provided of the evidence on the question of whether Reish actually was the one who promoted my client to the regional sales manager position. In fact, what he told my client was that he didn't think she wanted to get into sales management. And then rather than putting her up for promotion using the promotion process at Tactile, he made her go through the external hiring process. And that is key to how women got hired at Tactile. Karen Dupree, Stephanie Tongas, and Tracy Simplewich, all female regional sales managers, all came through the external hiring process. Under that process, the candidate interviewed with 6 to 7 Tactile employees from different departments, including Mr. Reish, but not exclusively Mr. Reish. And according to Mr. Reish's testimony, those 6 or 7 individuals then had to reach a consensus decision as to whether or not that person was hired. Whereas normally the promotion decision was solely in Mr. Reish's discretion.
Mhm.
So,
Ms. Abernathy, you've got some time for rebuttal, and we very much
Sure.
appreciate your argument. I'm going to ask my co-counsel, my colleagues, if they have any further questions of you.
I just have one question coming back from what you just said. So am I to understand that Mr. Reish could hire on his own hook and did hire the men?
the men also went through that same external hiring process. However, what
Well,
I
then why are
what
you
I would
making
note,
Sorry.
sure, what I would note though is that each of the women I just named for you were terminated by Reish, and Reish, by the way, had the sole termination decision. So they were terminated by Reish very quickly after coming through that broader hiring process.
Termination that you object to of them. I don't know.
Correct.
We went through this whole thing about the process.
Well, the point being that my client was not hand selected by Reish for promotion to regional sales manager, which was the usual promotion process, is that Brian Reish would just propose a slate of candidates for promotion and the executive committee would vote it up or down. That's not how she got her promotion.
That Reish didn't hire her alone. She's hired by a committee.
Correct.
And he did fire her.
And he did remove her from her position.
Right.
Correct.
Okay.
Are there any, Judge Motz, do you have any
No.
other questions?
I want to clarify what.
Judge Niemeyer, do you
I'm
have
fine.
any other?
I'm fine.
All right, well, we thank you very much. And
Thank you, Your
is
Honor.
it Ms. Gantz from the EEOC? Who's representing the EEOC? Are you representing them, Ms. Gantz? I think you
You're
need to
muted.
unmute your
Muted.
microphone. so
Unmute yourself.
Thank you. May it please the court.
There.
Can I go ahead? I'm Julie Gantz for the EOC as amicus. Thank you so much for allowing me to be here this morning. We're participating in the case to urge this court to correct the district court's total compensation approach used to disallow Sempowicz's Equal Pay Act claim. Because Sempowicz was paid a lower base salary in 2015, 16, and 17 to perform the job of regional sales manager, the same job in the same establishment as Sealing, she established a prima facie case under the Equal Pay Act. That she received more in commissions than Sealing in 2 of those years, which earned her a higher combined salary, in no way obviates her prima facie case nor exonerates Tactile from its obligation to provide the same rate of pay to its male and female regional sales managers.
There was no difference in their jobs. I mean, they had similar positions and similar.
That's correct, Your Honor.
Let me ask you this. I'm looking at this chart on 730, and it's got the 9 regional sales managers, and they're all making between 120 and 135,000. And they're all making different amounts in that range. And the highest amount is actually Jackie Gorham, and she's a woman. Greg Sealing's getting 130. This is back in 2015. Karen Dupree's getting 130, same as Sealing. And the plaintiff's getting 120, as are some other people. In other words, they're all within a range, but they're all different. And my question would be is the fact that these sales managers, 9 of them, are getting different incomes all within a range. Is that a violation? It looks to me like they're being compensated based on some aspect of the territory they have, the scope of the clientele and so forth, and maybe their experience.
Well, Your Honor, that would go to one of the affirmative defenses, but the Equal Pay Act deals with individual claims. It's not a class claim about all the women versus all the men. So as long as Sempowich is being paid a lower base rate than the male comparator, Greg Sealing.
Well, how do you,
and that's the Maryland insurance case that talks about how it's an individual claim.
I know, but none of these people are paid exactly the same. In other words, this is not a situation where they're fixing the salary on a gross assessment of the fact that the person's called a regional sales manager. In other words, every regional sales manager gets a compensation somewhere between 120 and 140, maybe, whatever that list shows. But it shows variously men and women getting different amounts, all fairly close. And it shows, for instance, Tracy Sempowich, she started at 120, she went to 130, and then she went to 140. And she passed up others in that regard. Jackie Gorman started out at 135 and went up to 150. Sealing started out 130, he went to 135 and then 142. In other words, these people are all making different amounts, but within the same range. And the question is, you're saying, if I look at that chart, that's a violation of the Equal Pay Act?
But Your Honor, the prima facie case is to show unequal wages.
No, answer my question. I don't want to go to the statute. I want to go to the notion that all these people who are regional sales managers are getting roughly between 120 and 140, disparately though. And there's obviously a basis for that, probably the size of their territory. So if one person has 3 states and another person has 7 states,
but here
in their assignment, they get that rate of pay. Now you're suggesting to me that just looking at this chart is a violation of the law.
No, Your Honor, the violation of the law is that Sempowich was paid less than Sealing to do the same job under the same conditions. Then the burden
Well, they didn't have the same job. They had different sized territories. They had different performances within those territories, and they got different levels of commissions. And the question is, as the years go by, you put together these amounts, they're not far apart. I mean, we're talking about every one of these sales managers got within the same range. And you look at the commissions on that chart, they all had different amounts, which probably reflects a lot of the size of their territory. But this doesn't scream as a situation where women are being paid less than men. I mean, there are women here. The one woman is the best paid of all of them.
But that's
Jackie
because
Gorman.
of the sales commissions, Your Honor.
No,
She outperformed.
No, her base pay was 135. She was higher than anybody then. And the next year, 150, which was the highest on the whole chart.
But to make out a prima facie case, you only need to show there's one comparator, male comparator, that is making more money for the same job. And the issue in this case was that the district.
Well, why is Jackie Gorman different from Tracy Sempowich or different from Stephanie Tongas? And they're all making different amounts, and they're all women.
But that would go to a factor other than sex, which is not before the court right now. The issue is that the district court confused total wages with wage rate. So there
I
are two
understand that
different rates.
argument, but what I'm suggesting is that if you just look at the evidence fairly and comprehensively, in some sense, it does not look like they are treating men and women differently. It looks like that men and women are different based on factors that are not their gender.
Well,
In other words, Tracy was making more in 2016. She's making more than a bunch of others. In 17, she was making 140. There was only one person higher than her. That was Sealing, and he was only making 142. And the year before, Jackie Gorman made 150. So it doesn't make sense. You're sort of carving out a statistic and saying we're going to take two statistics which are really not the same because they're not the same territories, not the same performance, not the same experience.
Well, Your Honor, I would direct you to the Maryland insurance case. That talks, this is not a class claim.
Well, address me on the facts. First, stick with the facts on this. What's wrong with my analysis of the facts?
What's wrong is that Sealing was paid $130,000 compared to her $120,000 in 2015, $135,000 compared to her $130,000 in 2016, and then still $2,000 more in 2017 to perform the exact same job under the same working
Why do you
conditions.
say it's the same job? Weren't the territories different size?
It's undisputed the job is the same.
It's the same title.
It's the same title.
They have different responsibilities based on size of territory, right?
It's undisputed the job is the same. It is
Well,
not
why is David Humiston getting only 130 while Sealing is getting 135?
I have no idea, Your Honor, but that would go to a
Well,
factor.
don't we have to take that into account? In other words, you're looking for discrimination based on gender.
Based for just Tracy Sempowich, and there's a comparator who is doing the exact same job under the same working conditions, who is being paid a higher rate.
You think somebody who has 9 states is doing the same job as somebody who has 7 states or 20 million people?
It's undisputed the job is the same. They're both regional sales managers. That is not even at issue in this appeal.
You think all vice presidents of a company all should be paid the same? Some of these large industrial companies have 20 vice presidents, and they're paid enormously different range based on the scope of responsibility. I mean, we're in an executive level here, and
Agreed. You
have to look to see whether this is motivated by gender. You have to look at what the company's doing. And I must say, I'm very troubled by this nitpicking of a particular statistic in a broad range of statistics, which look very benign from looking at them. And you're saying, well, you can pick one number where a male's getting more in 1 year and a female's getting less. They're all regional sales managers.
That's what the law is, Your Honor. It's an individual claim. It's not a class claim. And it is undisputed.
But you have to look at context. We're looking at discrimination in the workplace.
Agree, Your Honor. And most cases under the Equal Pay Act are generally about whether the jobs are the same. But in this case, it's undisputed that the regional sales manager job is the same. And the only issue—
undisputed. It's not undisputed.
It is undisputed.
They described Tracy's territory, and they described Sempovich's territory. And her territories changed from year to year. Everybody's territories changed as the company made reassignments based on growth statistics, reorganizations, that type of thing, which was external to these two people. But the fact that they were paid differently for different sized territories, I'm really surprised that the government's taking that position.
But the district court found that the two jobs were the same, and the only issue on this appeal is whether they were paying a higher rate to Sealing than Sempowich. And the problem—
I gather your point is that you take exception to the methodology that the district court employed. You're not saying how the Equal Pay Act claim could come out or would come out, as long as, in your view, the correct methodology is employed, which is to require the wage rate to be the same as opposed to total salary with bonuses as a component.
That's correct, Your Honor.
I mean, I thought, and so, I don't know how it all comes out on remand, but I do understand what you're saying. That is, if you're just saying that if you don't look at wage rate, then if you look at just total salary, then you're in danger of penalizing a female employee who works more overtime perhaps, or earns more in commissions or bonuses or whatever. So I think, Judge Niemeyer has a really good point, but as I understand, your view is you're not looking at what people are earning, or even at this stage whether their job is similar. You simply want to know whether there's a differential in the wage rate.
Correct. And in this case, in this case, there were two rates of pay. One, the annual salary, that's a time-based rate for hours worked, and then the commissions, which is a percentage of sales, and that's a very performance.
Well, I don't know what I'm not prepared at this point to say what the wage rate was, or that whether it was differential or not. It's just a matter, as I see it, of making sure the district court asks the right question.
Well, the problem is lumping the two rates together, because there's no
Well,
one.
I understand that argument, and I'm granting you that argument, because this chart lists base salary and then it lists commissions. And I was leaving off commissions because commissions are very disparate. But I was looking at base salary, and everything I was talking to you was about base salary. And I noticed that for the very same job, Adam Firkenhoff in 2016 made $144,000, while Greg Sealing made $135,000. Now, if it's the same job, they should be getting the same pay according to your position. And yet they're not getting the same pay. And the explanation you would give is that would, if they were different genders, that would be discriminatory. But yet they give a different pay to two men for the very same job. And so there must be a different factor involved. And they did explain the different factor, which was size of territory.
But
That's not what the court relied on.
right.
Oh, district. I agree. We have a problem with the district court's analysis. On
No, so a lot of what my friend Judge Niemeyer is suggesting would be sorted out on remand. The problem I have is that there may have been an incorrect standard applied under the Equal Pay Act, which is that just fundamentally, to treat men and women equally, you have to give them the same wage rate for the same job. And that's the question the district court has to ask. And maybe the company can come forward with something and say, but at any rate, I don't know, we can resolve it up here, but if it's okay with you all, I would like to thank Ms. Gantz for her presentation. We appreciate having you.
Thank you.
And I'd like to hear from Ms. Parker, unless either of my colleagues has further questions.
That's fine.
Well, let's hear from Ms. Parker. Let's hear your side of it, Ms. Parker.
Thank you, Your Honor, and good morning. My name is Kristen Parker, and I'm here on behalf of Tactile Systems Technology, Inc. It's Tactile's position that the district court correctly entered summary judgment in its favor on all matters. And I had planned to turn to the discrimination claims first, but given the current discussion about the EPA claim, I briefly would like to address that and then return to my intended argument. So Judge Wilkinson, you had just raised the question of whether the Court of Appeals could affirm or address this EPA claim on another basis that the district court did not. And I would contend that the Court of Appeals absolutely, even if the Court of Appeals determined that the district court applied an incorrect test when it aggregated forms of wages. And there were two kinds of aggregation that I think were challenged, both wages and incentive pay. And it's not a straight commission. So it is different than the case in Keziah.
Well, maybe I'm just wondering if some of this shouldn't be sorted out on remand. I'll tell you what concerns me here is that women would be unduly penalized simply for being more successful at the job and for getting more, there would be a differential in the wage rate, and yet the woman would be totally compensated at a higher figure, but that may be due to her efforts. It may be due to her initiative that it was on her success was what led to her higher salary. But I'm not sure that the company wouldn't prevail on this. But all I'm saying to you is I think it's very important that women not be docked and disadvantaged because they had earned more in commission or had shown more initiative. And I think the inquiry into wage rate helps to protect against that. And that's that's a big deal for me, because I think people ought to be rewarded in accordance with their talents and efforts. And if there's a differential in wage rates, that's fundamental. But I don't know what the objection is to having the district court look into it further.
Yeah, so I agree, Your Honor. And if this court determined that the district court made an incorrect decision at the prima facie case, the Court of Appeals certainly could remand. The Court of Appeals could also, though, there is an adequate basis in the record for the Court of Appeals to affirm on alternate grounds, which is the affirmative defense of other factors other
You
than.
put the, you put the affirmative defense before the district court. District court didn't reach it. The only thing we have here, do you concede that the rationale the district court gave was erroneous under establishing a prima facie case under the Equal Pay Act? I don't see how you can not concede that.
So I think that there is a potential issue if in all cases, each various form of compensation has to be disaggregated, and any minor difference in a form of compensation, when it's, in this case, it's a very small percentage difference, where you have both men and women making more, and men and women.
And I understand that. And I thought Judge Niemeyer did a really excellent job on that, but that goes to the affirmative defense. That doesn't go to the base, and the base was different here. I just don't understand why you don't concede. Yes, that is an improper, that would violate, that's a prima facie case under the Equal Pay Act.
Sure, I mean, that is, I concede that they are different. I think the part that I
That's not what I asked you to concede. They've made out a prima facie case. Maybe you have an affirmative defense, right?
Yeah, yes, Your Honor. So she did make less than another man. But there are men who would then also make out a prima facie.
Okay, so do you or do you not concede that she made out a prima facie case?
Your Honor, I concede that there is a difference.
You've read the Equal Pay Act, right? And you've heard the questions from the panel.
Yes.
So you don't concede it, or you do concede it?
I concede there's a difference, and
no, that's your question. Yes. You don't need to say yes, you don't need to say no, but you have to say one or the other. Did she make out a violation, a prima facie violation, or affirmative defenses? Did she make out a prima facie violation of the Equal Pay Act?
Your Honor, I think it's, I struggle with that question myself. I think it's a hard question for
so you
the panel.
To the question, is that it?
I'm sorry? No,
you were refusing to answer the question.
Coming into this, I didn't think that Fourth Circuit case law necessarily held that that one difference in one type of pay would do that. I hear you, Your Honor, saying that is your.
No, I'm saying what I'm trying to do is to figure out what the law is here.
Mhm.
whether you're challenging the prima facie case or whether you're saying, no, we have an affirmative defense. And that's all I want you to tell me.
Sure. You know, I think that our stronger case is on the affirmative defense. I would be willing to concede that there is a difference in pay. And coming in, I did not.
When you say difference in pay, do you mean difference in wage rate?
Yes, a difference in wage rate in that isolated instance. Yes. And so if the court holds that that is the only thing that is required to establish a prima facie case, then I concede that she's made a prima facie case.
Well, let me take the question further. Rather than having us conclude, the question is, what is your position under the Act? Does that state a prima facie case? The differential.
So the regulation that the EEOC.
No, the question is, does it state a prima facie case? And you could, if you don't have an opinion on that, it'd be very strange. But if you have an opinion, I'm interested in it.
So the reason that I find that this question challenging is that wages include all forms of compensation. And so
now look, let me ask you a question. You've just conceded there was a differential in wage rate. Now, my question to you is a straightforward one. Under the law, does that state a prima facie case as you understand the law?
Your Honor,
the government says it does, and in your inability to reject that, it seems to me the government should position should prevail on that. Then that's really what you're leaving us in terms of argument.
Your Honor, I will concede the prima facie case. I think there's some potential illogic to the idea that any difference, no matter how small, it's a prima facie case. But it's hard to say under the words of the Act that that's not true if this court accepts the conclusion that all forms of compensation must.
All right, if you concede, as you have, that this is a prima facie case, then the next step is to have you provide a justification, right? As an affirmative thing.
Yes, Your Honor. And
the district court didn't get there, right?
That is true.
Okay.
But this court may get there if there's.
I understand you'd like us to assess the affirmative defenses, and maybe there's a situation we can do it, but it's
There's
also
nothing wrong with letting the district court look into it. That's all we're saying. A lot of this is, one of the problems with this case is we have this massive record. This is thrown around and this is thrown around, but this is something that a district court ought to look into with the proper methodology. And I think the EEOC has an important point to make, that the methodology has to be correct, or it's going to lead to all kinds of problems and inequities that seem to me contrary to what the Equal Pay Act is trying to achieve. But why don't you get on to the other claims, Ms. Parker? We'd be pleased to hear from you on those.
Yes, I would like to do that. So let's move to the discrimination claims, because the Equal Pay Act claims can certainly be separated from the rest of this case. With respect to the discrimination claims, I know you've mentioned the record is lengthy. I think it will come as a relief to Your Honor that I believe there are just a handful of key undisputed facts that the district court correctly found, which can dispose of Ms. Sempowicz's discrimination claims. So briefly, and then I'll discuss them in more detail. First, during Ms. Sempowicz's employment, especially during 2017, Tactile asked Ms. Sempowicz to meet several specific performance goals related to year-over-year growth, related to retention, and related to employee development. Ms. Sempowicz, second, this is the most critical piece. Ms. Sempowicz admitted that she failed to meet those performance goals in 2017, at least on 3 occasions. Third, Tactile consistently explained its reasons for removing Ms. Sempowicz from the RSM position. And before getting into those facts further, I want to acknowledge that on other points and at other times, Ms. Sempowicz received positive performance feedback. That's not unexpected. You've got an employee here who was promoted on multiple occasions. That Sempowich may have performed well on some goals does not create a material dispute that she did not meet certain other performance goals that Tactile established. And finally, even as Tactile removed her from the regional sales manager position, it offered her another position that it felt played better to her strengths. So it's not unlikely that they would find she had some strengths.
So I think that's, I hear you on that. But my problem is that Tactile gave her these awards. Okay, her employment ends in March 2018. It wasn't 4 years before. In January 2018, they gave her the Regional Sales Manager Leadership and Sustained Excellence Award and $10,000 salary raise in February 2018. So it just seems like in a month she'd done so poorly that she was fired or transferred to a less lucrative position. That seems at least to raise a question of fact.
Your Honor, I hear the tension. I don't think it raises a question of fact as to whether she performed on the specific goals that were relevant to her position as a regional sales manager managing a group of individuals.
But didn't those awards deal with that too?
So, Your Honor, when you review the record, the sales awards very clearly lay out the criteria. They were a mechanical application of sales metrics, of sales and revenues versus targets. And those targets, as Your Honor will recall, were reduced repeatedly across 2017 based on the failure to fill headcount. So that quota was reduced the revenue target, and then Sempowich overachieved to those reduced targets. So
and I think that's why this record is so muddy. Maybe so, but is this summary judgment?
I think it is, and here's why. It is because it is reasonable for Tactile to say for a regional sales manager, what that regional sales manager needs to be able to do is to retain, grow, and develop a group of sales individuals.
But is it reasonable to fire her or demote her a month after you've given her this award, a salary raise, and these awards?
Yes, because they are based on performance to that adjusted quota. They are a mechanical application.
And that's your explanation. And good for you. That's why there's an issue of fact.
So I don't think there's an issue of fact as to the other performance standards they held her to, though. So I think most—
Well, no, because they say what it is. Of course, she can't make an issue of fact with respect to that. All she can do is point to this and say, no, that wasn't the real reason. You don't expect them to fall on their swords and say, well, no, and create their own issue of fact, do you?
I don't, but what I think is really compelling is that Tracy Sempowich herself admitted those failures repeatedly. If you look at the appendix at 807, there's a business—
And she has various reasons for them, doesn't she?
She does.
So,
she explains
so
why
she has an explanation. We're not getting the support, getting the smaller territory, etc. And maybe that's all wrong, but that's why this record is so muddy.
I understand.
Ms. Parker, I gather you would say that the award that my friend mentioned, that's not evidence of discrimination.
No.
To the extent that women are awarded things, it's evidence of appreciation, not discrimination. So that's a fact that, it seems to me could well cut in your favor. And you don't want to discourage companies from giving women awards. And they don't want lawyers sitting in there, well, watch out, if you bestow these awards, you're opening yourself up to a discrimination suit. I'm nervous about having that cut against the company because I want to see female employees recognized, and I don't want to see the law build in a disincentive to giving them awards for whatever the award is offered for.
And I wasn't suggesting to the contrary. What I was trying to do, and I perhaps was inarticulate about it, was to suggest that this supports her claim, or at least raises a question of whether the company legitimately believed she was performing poorly after they just had given her these awards.
So again, Your Honor, I would say the fact that the awards were based on the reduced quota that was reduced at her request, that was reduced because she couldn't grow the headcount, can show both that the company treated her very fairly as a regional sales manager in continuing to make her eligible for that award, and also that the company had legitimate criticisms of her ability to retain and fill that headcount.
And a fact finder might find that.
When there's another point here, Ms. Parker, that I wanted to bring out. When the plaintiff did fail to meet the goals with respect to growth in sales and the rest, the record seems to indicate that the company actually extended coaching to her, and they wanted her to meet the goals, and they extended coaching opportunities and said, look, here's how you can go ahead and meet this goal. So doesn't the coaching go to the fact, number one, that she was failing to meet the goals, and number two, that the company wanted her to meet the goals and was prepared to extend coaching opportunities to make sure that she met the goals? I mean, in other words, you know, it goes back to what my friend Judge Niemeyer said earlier. There's a lot of information, and it's certainly muddy, and there's a mountain of information. But at the bottom of it all, is there real discrimination here, or simply business judgments being exercised? And that's, you know, when you take a number of these facts together and look at what the company's goals were, and you look at the fact that they were awarding things, and you look at the fact that they're coaching her, and you look at the fact that they're making her a manager, and even though it doesn't go to the Equal Pay Act claim, they're making her a management and putting her in a position where, through her own efforts and otherwise, she's making $806,000 a year. And they're putting her in a position where she can make, if not 806 with some effort, but if they're putting her in a position where she's a manager, number one, and would make a great deal of money. If you're going to discriminate against someone, why would you make them a management? Why would you extend the coaching? Why would you put them in a position where they can make, you know, $750,000 or more of $1 million on an annual basis? That doesn't sound like, to me, somebody's out to get somebody on account of a prohibited basis. That doesn't, to me, that doesn't affect the Equal Pay Act claim. That's a distinct issue in my judgment. I'm just talking about the point that Judge Niemeyer raised about when all is said and done and the smoke clears, there's lots of smoke. And goodness knows you can go forward with circumstantial cases. I don't want to be misinterpreted as saying that direct evidence is the only way to go, because it surely isn't. But I'm just wondering where the discrimination is.
Yes, Your Honor. And if I may, I would like to address that point, because even if you believe that Ms. Stempowich can make a disputed issue of fact as to her prima facie case, a disputed issue of fact that she was meeting the company's expectations, I do not believe that she can make a pretext case. First, because she cannot show that the reasons proffered by Tactile for removing her from the RSM position are false. But secondly, because there is nothing in this case that establishes pretext or that gives a suggestion of pretext. And I wanted to address the point that Sempowich made with respect to the standard of pretext applied by the district court. The district court did not apply a heightened pretext standard. The district court quoted directly the standard from Labor versus Harvey that states that appellant may show that, or that the plaintiff may show pretext by showing that the articulated reason is false, but that they must show that there was discrimination. And in some cases, they can show discrimination from the articulated reason's falsity. But this case is not like those cases where the court said there's something here. And first off, the criticisms Tactile had are not shown to be false. Is there, as Judge Mott says, should we find that they're outweighed by these other things? That I can't tell you, but they are not false. I believe that the court found.
The employer replaced her with an employee who they had rated less than her. I mean, I just think that you can just give us one side of the story, and maybe that's what you want to do and think is most effective. But that's not what we can do. We have to look at the whole record and all of the evidence. And as my friend Judge Wilkinson said, and Judge Niemeyer said, there's certainly a lot of it. And we're not saying, as I understand it, they haven't asked for summary judgment. I don't think they would be entitled to summary judgment. But the question is, are there enough disputed facts here that you're not entitled to it either? And you just can't just look at your evidence and say that.
Right.
If they replace her with somebody who they have rated less, but who is a man.
So there are two things that I'd like to say to that. First, in the prior performance evaluations where Mr. Sealing was rated lower, that was a year prior to the decision to replace her. And there's a lot of case law that says we're not going to take a performance evaluation from a year prior. And
I know, but then the response to that is they removed Maryland and Virginia from her region, which were two most powerful or most lucrative. I mean, there's a comeback to all these things, and you can just ignore them. But believe me, my colleagues, and I hope I will look at the whole record. And so your argument has to be even this, and this, and this, and this that they put on. And you don't do that. All you do is talk about your evidence.
So Your Honor, I'm happy to talk about their evidence. I think there's a lot of smoke here, but there's really not a fire. She talks about Greg Sealing golfing with Brian Reish. But in fact, there's evidence that Ms. Sempowich was also asked to golf with Brian Reish. She talks about exclusion from certain meetings, but it's a very high level general argument that she was not in a meeting. There were many different meetings that took place with many different people. There is not kind of a nut that says, other than her invitation to the court to speculate that this is based on sex, there's not a nut there. And if all that it takes to get to trial is to say, I can, say that they went golfing and I can say that they were friends.
But that's not all the evidence. I just, if you want to ignore the strongest, okay. What about they stated that they fired her in part because of her low hiring and high turnover, and then they listed people development and team building as her exceptional strengths in her performance evaluations. So, I'm not going to go through each piece of evidence, but what I think you have to do is to look at the mixed record here. And a lot of it is my colleagues have put up.
And there is a lot of record. I acknowledge there's a lot of record. I think critically, Ms. Sempowich's admissions in 2017, that she was not able to build her team, that she had empty headcount, that she was not able to fill the slots in the DC territory and underneath Thurmany Desai, who she was supposed to be developing. And that she admittedly, in a conversation that she recorded and that she didn't tell Mr. Reish she was recording, she said to Mr. Reish, What I'm struggling with is that I couldn't grow the way that you wanted me to. She then argues that there were factors that were outside of her control. And I don't expect her to agree. And in fact, the fact that she can point to disagreement is not surprising. This court in Hawkins versus PepsiCo said that that is not a surprise, that that does not create an issue of pretext. This court has also addressed that issue in Jones versus Lowe's, where they talk about Jones not being able to claim unfair surprise. Ms. Sempowich was very aware of the criticisms of her performance. And her dispute, her quibble, her belief that the good of her performance should outweigh the issues that were raised by Tactile are simply not sufficient to get to trial.
All right, thank you very much. If there's some further questions, we'd be happy to hear from anybody. And Ms. Abernathy, you have some time for rebuttal.
Thank you, Your Honor. I just want to address two overarching points that got discussed very quickly. The first is, I do want to emphasize, we are not asking this court to decide any issues in this case in our favor. In other words, to say that my client wins. All we are asking this court to do is to take this, as I've heard it described, very muddy record and send it back for a jury trial, for a finder of fact to draw from the various evidence presented by the parties what inferences they believe are reasonable in this case. I understand that as judges and as people who are very involved in what you're looking at and what you're doing, it is very tempting to start trying to draw some of those inferences from your own experience, background, and beliefs. But that is ultimately a jury function. And all we are asking this court to do is to allow the jury to do that function.
Ms. Abernathy, one of the things you talk about is all of these things go to the jury, but you know, there are decisions like Celotex which indicate that the plaintiff bears the burden of creating an issue of triable fact. And the summary judgments standard does have two limiting words to it, which are genuine and material. And the Supreme Court has told us to look at the record as a whole, not just that the proof scheme, which emphasizes prima facie case and pretext and the like, that's primarily for a proof scheme for district courts, but that the Court of Appeals has to take a holistic view of the record and as to getting to trial, plaintiff bears the burden not only of the ultimate question of discrimination vel non, but also you have to create an issue of triable fact. Now, you know, you think you have, the other side thinks you haven't. But just the fact that what concerns me is that just the fact of disagreement about a particular decision that's made in a shop, or just the fact of disagreement about something of a place that somebody is assigned, or whether they were treated fairly or whatever. In every workplace in the country, there's going to be disagreement over things that happen within a business, but it is not, you have to go from disagreement to discrimination. And that's the step that it's most difficult to take. And there are a number of undisputed facts here that argue against discrimination. Not that they don't argue against disagreement, but they do argue against discrimination. And that's the problem. And you bear the burden of creating an issue of triable fact.
And Your Honor, I will grant you that there have been a number of facts here discussed that, are not necessarily ones that are helpful to my client's case. One that I want to point out in particular is looking at, for example, what happened to other women in the company. So, for example, looking at what happened to Ms. Gorham or looking at what happened to Ms. Dupree, the U.S. Supreme Court has been very emphatic over a number of decisions that is not an appropriate place to look for evidence, that it is not relevant what Tactile did or did not do with other women at the company.
Okay, but let's look at this individual, at the individual plaintiff. If you're out to discriminate against somebody, why wouldn't you just dismiss them? Or why would you put them in a position of earning $750,000 a year, and when the goals were not met, there was repeated coaching to try to help the individual involved meet those goals? And why would you put the individual involved as a regional sales manager? I mean, all of these things raise a question of me. I'm sure there were decisions with which the plaintiff was dissatisfied, but there are things about your job and my job and the judge's job and everything. There are a lot of things that I'm dissatisfied about, but I don't think it all translates into discrimination, because the work environment, the decisions don't please everybody. I wish they did.
Your Honor, I do want to address briefly and I know Tactile has argued this or characterized the record this way, but you have on several occasions mentioned that my client received coaching. I would point to you JA 2070, which is Brian Reish's deposition admission that he couldn't remember there being any coaching. And the documents that Tactile has put up, I would encourage your clerks to take a close look at those JA sites from Tactile's brief when they give their string citations where they say there was a history of coaching. You won't find the words coaching in there. In fact, you won't even find any direct criticisms of my client's performance in those documents. So we strongly dispute that characterization or that inference that my client received some form of coaching. And the evidence does not support that. I would also note that
what was it that she did receive?
What she received was an email from Brian Reish dated August 2nd, 2017, that she had actually asked him to send the day before, and we provided that email to the court as well, that was addressed to the two sales recruitment managers at Tactile, asking them to help source candidates for her to interview. And what Tactile has cited is they've cited that document and they've cited some other testimony surrounding it. But what Tactile is doing there is they are drawing an inference from a document that is not plain on its face, that does not plainly show any coaching of any sort on its face. They have drawn an inference from that and are pursuing that inference. And I would just point out that part of the summary judgment standard is that this court is required to draw all reasonable inferences in favor of the non-movement.
I know we go back and forth on that, but the plaintiff is also required to have genuineness and materiality, and it's there are things that each side can argue about. In the end, it comes down to something of a judgment call, really, as to whether something is triable or subject to judgment as a matter of law. But Ms. Abernathy, I want to say how much we appreciate your being here, and I hope, can you give us just a minute of summation or something so I can give you the final word here?
Absolutely, Your Honor. And so we would respectfully request that this court reverse the decision of the district court and remand this case for trial on the merits before a jury where the parties can argue all of the various evidence and inferences that you've heard today, and a jury can sort it out and determine what the final facts are. And that's the sole relief we're asking for here. Thank you, Your Honor.
Judge Niemeyer, Judge Motz, do you have any further questions of Ms.
No.
Heber?
Thank you.
I want to thank all three of you for a very fine argument. You represented your clients and positions very well. And I wish we could come down and greet you and shake hands and thank you personally for the fine job you've done. But I hope you'll always take a degree of satisfaction from the very high quality of the argument we've received. Thank you so much.
Your Honor.
All right, we'll move right into our yes, you may.
Good morning, Your Honors. My name is Dallas Sapir. I'm here representing the plaintiff appellant in this case, Brad Favor. This case, Your Honor, is a claim under our LUPA for a substantial burden on Mr. Favor's sincerely held religious belief that he must pray with prayer oils that have been purchased from a vendor that does not sell swine and idols. Specifically, the allegation is that the VDOC's policies of having one contractual vendor for all items substantially burdens that belief by not permitting Mr. Favor any opportunity to purchase prayer oils that are not sold by a vendor that sells swine and idols. In this case, Your Honors, there is no serious contest as to Mr. Favor's sincerely held belief, or the substantial burden to that belief. Nor is there any serious contest to the defendant's VDOC's allegations of a compelling governmental interest. Specifically, the governmental interest is a cost containment and security measure. The question at issue is whether or not the district court, as this was a trial to a judge rather than to a jury, correctly applied the legal standards to the evidence in this case to determine that the single vendor policy of the defendants was the least restrictive means.
When there's been a trial, why isn't the question of least drastic means a question of fact?
Your Honor, I believe
the magistrate judge heard a great deal of evidence going to the question of least drastic means. Heard from plaintiff and heard from corrections officials. And why isn't, after where you have a trial, why isn't the least drastic means test a factual one?
Yes, Your Honor. In this case, there's actually two steps to that process. The first is the argument that the district court incorrectly shifted the burden from the defendant to prove least drastic means, least restrictive means to the plaintiff when stating that the alternative that the plaintiff had presented, in this case, a single vendor contract with a religious vendor, in addition to the non-religious contract they have with Keith. The court said that the plaintiff had not presented sufficient evidence that that was a possible alternative. I think that was both factually incorrect, but it was also an incorrect application of the legal standard in an RLUPA case. Again, the plaintiff has the burden of showing a substantial burden to a sincerely held belief. At that point, the burden shifts to the defendant government under a strict scrutiny standard to demonstrate that the policy at issue is the least restrictive means of meeting a governmental interest.
Well, one of the difficulties here is that, unlike in many cases, here the correctional facility had actual experience with what you're thinking, what you're posing is the least drastic means. In other words, the corrections department has experience with multiple vendors, and that posed all kinds of difficulties. And the district court, the magistrate judge, listened to the testimony on that fact and credited that testimony. Because a lot of these cases, we have just speculation about whether something would be a least drastic means or not. But here, the multiple vendor option, which you're suggesting, and is something that they already tried and then they had to give it up in 2013 because it created multiple problems.
And Your Honor, the evidence is that the defendant had always had a policy of having one vendor run their commissary. And then on an individual basis, in individual facilities, an inmate would request to source something themselves directly from a vendor of their choice, and exceptions would be made on an ad hoc basis. So there was no unified policy, there was no single vendor for religious items. It was vastly different and unapproved sources that had to be made individual exceptions for. We do not disagree that the VDOC had a need to move away from that ad hoc, Wild West kind of approach that they had going on, where anything could be purchased without prior approval of the specific item from any vendor that the individual inmate has chosen. Our position is that
one of the things that you say, well, we want an Islamic compliant vendor, and would we also be required to have a Hindu compliant vendor and a single Christian compliant vendor, or a single Catholic or Baptist compliant vendor, or an Orthodox Jewish compliant vendor? And if we have compliant vendors for some religious faiths and not for others, don't we run into an establishment clause problem? I mean, the state can't be sort of picking and choosing among religious faiths as to what it has a compliant vendor for and what it doesn't. I mean, it seems to me you're courting establishment clause difficulties. That would be the next suit.
Your Honor, the concern here is that the defendant has placed no evidence in the record that indicates that they've ever had any prior suits, any grievances, any complaints, or that there are other religions even that would require a vendor other than Kifi.
But you know, I'm not sure the burden requires there to have been actual factual breakdowns of security. It seems to me that when the prison authorities say we have difficulty with bringing in containers with liquids, it's a matter of common sense that liquids can contain poisons, they can contain alcohol, they can contain explosives, all kinds of things that need to be checked. And as a consequence, we don't have to have a circumstance where somebody was poisoned to believe that. And as you probably remember, in Green Hill, we addressed this type of thing, and we suggested that the VDOC doesn't have to consider all the conceivable possibilities. It really needs to address the suggestions you have made, and it seems to me their suggestions are not hollow. I mean, they're worried about several things: efficiency, compliance, security, safety of the prisoners, safety of the prison circumstances, compromise of the prison penological interests. And while your client has a good faith belief, unfortunately in prison, he can't have everything. He can't go to a cathedral. It's I think the courts ought to be very sensitive to religious practices in prisons. I think it's very beneficial both for the prisoners and for the system to have that. And we've recognized that in prior decisions. But this case, we're faced with the question, has the VDOC just made something up for convenience, or are they articulating some efficiencies, expenses, security issues, and so forth that are real? And your suggestion they have to experience adverse consequences as opposed to pointing them out. 40 different religions' faiths is just one thing, but there are tons of others too. It's just a matter of, and by aggregating them through a single vendor, they create this one problem of, they're willing to give them the holy oil, but they create the problem that the vendor does sell a Christian cross. And the Christian cross is, of course, an idol that is not acceptable. And this may have to be some area where the balance, district court may have drawn the right balance. I don't know. Maybe you persuade us otherwise, but that's my concern right there.
Yes, Your Honor, and I acknowledge that the single vendor contract is a method of addressing those concerns. My issue is the contract provides for key fee to both bring the items in, and they do actually do a security check of all items that are removed from the package, bagged, x-rayed, and scanned, that's coming into the facility before it crosses the secure boundary. That is done for all objects that enter the facility.
No, you're absolutely right. You're absolutely right. But in other words, they may do their own check anyway. But yes, they have pointed out that they have a relationship with this vendor, and they have called it a pretty high level of contractual trust. They even have used the word, I think, fiduciary with them. They trust this vendor, and so the vendor is not going to be aiming or helping compromise the perimeter. The prison still has to do its own checks, no question about it. But if you were dealing with a vendor, hypothetically, that would be attempting to compromise the perimeter, you can hide things in televisions, you can hide things in vials, you can, there's all kinds of methods by which to sneak things in. And that risk increases if you all of a sudden have to go out to hundreds of vendors in order to satisfy the needs of the prisoners. And that's sort of a matter of common sense, isn't it?
Well, Judge Motz has a question for you.
I was reaching off of that question that Judge Niemeyer raised, and it seemed to me that in your questioning of Ms. Vargo or Mr. Vargo, anyway, whoever their witness was, that person had conceded that they had never considered and rejected entering into a contract with an Islamic vendor. It was the contract that they had with this other vendor that, as Judge Niemeyer just pointed out, gave them a lot of assurance. Now, if that was a viable alternative, that is entering into, it could be exactly the same contract with an Islamic vendor that would give these oils, isn't that something that they should have considered? And it was put into the record that they had not done that.
Yes, Your Honor, that is our argument. And in fact,
well, you never said your argument. So
I apologize.
Didn't say it orally.
I apologize if I wasn't clear. We actually proposed that they should have considered entering into a single vendor contract for religious items with Halalco, who is actually the company from which Keefe sources these oils that have already been inspected, approved, certifications are made. These are acceptable.
Contract that is important. At least that's what they said. As Judge Niemeyer pointed out, they got a lot of comfort from what was in the contract, and one can understand that.
Correct.
And what you did was ask them, the question of whether you decided that you would let this Islamic vendor in is not the same as getting a contract with Islamic vendor. And that is, I read the record, something that they had not considered or that they had considered and rejected.
Yes, Your Honor, that was the argument we proposed. The alternative we proposed was a single vendor contract that provides all the same contractual protections and duties that gave the defendant comfort with Keefe be entered into with a single vendor for religious items. And the defendants admitted, and Ms. Vargo admitted that had not been considered prior to the switch from an ad hoc to an entirely single vendor program.
Were the prayer oils supplied by Keefe Islamic compliant?
They were Islamic compliant, sourced from Halalco, yes, Your Honor, except for the fact that they were sold by a vendor that sold swine and idols, meaning Keefe.
Well, but if they were Islamic compliant, what is your complaint?
Yes, Your Honor, the oils themselves are compliant up until they are sold by a vendor that sells swine and idols. And it's not uncontested that Keefe sells both pork products and idols, meaning things like crucifixes and things of that nature, which Halalco does not sell. So once they pass from purchased by Halalco and then sold to the defendant, I'm sorry, to the plaintiff by Kifi, they are no longer Islamic compliant prayer oils.
I thought the DOC did address that by indicating that they have 40 different faiths that they would have to enter into contracts with, and there was some concern about the establishment clause and the checking out of those vendors. Some of them may be marginal, some may be safe, and whether they are prepared to establish that trust. I thought that was all part of what the response was to that.
Ms. Fargo actually testified that you might have to go down that road, or you tend to have to do it. She had no indication that there was any actual consideration of that, or any indication that that would be something that would become a problem if a single vendor, religious vendor, was entered into a contract with. That evidence simply wasn't in the record. And in fact, the district court ruled that the plaintiff hadn't proven that such a contract was even possible, whereas Ms. Fargo testified that if they were to consider a vendor contract with Halalco, they would have to make sure Halalco was the best option because there are so many options.
And, just as a suggestion to your response, it's not simply the contract that establishes the level of trust. It is the experience with Keith that establishes the level of trust. You can have all the contracts and everything in the world, but that's no substitute for the actual experience.
The testimony.
But the record in this case emphasizes that the witness representing the prison put a great deal of support, a great deal of deference to the contract. She seemed to think that that was the critical thing, as Judge Niemeyer pointed out earlier.
If you want we'll give you just a moment. I can point you to the appellate record at page 114, lines 4 through 6, in which the witness says it is the contractual obligations and responsibility that gives us confidence that we can bring in these items without the extra security measures and the extra costs associated.
They've had experience under the contract. The one question I have, aren't the prayer oils supplied by Kifi Islamic compliant? Don't they buy them from Islamic suppliers like Halaleo or whatever it is?
They are Islamic compliant when they're leaving Halalco's hands, but not when they leave Kifi's.
Isn't that worth a great deal that the oils themselves are Islamic compliant?
Unfortunately, no, Your Honor. Once they arrive at Kifi's hands and Kifi sells them to the plaintiff, under his religious beliefs, they are tainted by the swine and idols sold by Kifi, and they are no longer pure, and they impurify his prayers. So unless they are sourced directly from
there's no evidence of that, is there? I mean,
yes, Your Honor. Mr. Favor himself testified as to the source of his belief. He is a devout Orthodox Sunni Islamist Muslim. His beliefs are that all items have to be purchased from a vendor that does not sell swine and idols, or they are tainted. That he has to go to prayer to state of purification, and that impurifies him.
Okay, thank you very much. Any questions? Judge Niemeyer, Judge Mott? Ms. Cahill, we'd be happy to hear from you.
Good morning, Your Honors, and may it please the court, Laura Cahill on behalf of Harold Clark. In this case, the district court properly found that DOC first had a compelling interest in maintaining the prison security and ensuring efficient operations of prison facilities, and that the single vendor policy achieves those compelling interests. And
let's get right to the core of the argument that's made.
yes,
and that is what is the response for the Department of Corrections not entering into a contract with Halaleo, whatever the name of that company is? What is the response for not entering into a contract similar to the one that it enters into with Keith?
Your Honor, Mrs. Vargo testified at trial that entering into another contract would not achieve the compelling interests of maintaining prison security and secure operations, efficient operations that the single vendor policy does. It essentially would lead to a
Well, that's
multi-vendor
conclusory.
policy.
What are the problems he had? He had.
That it was a she.
She, excuse me.
That by entering into a contract, whether they considered it or not, entering into that contract wouldn't achieve the same means, because essentially they would be returning to a multi-vendor policy.
But aren't they required to consider the least restrictive alternative? And she said, she was asked, have you considered having a contract with a specific vendor to provide Islamic prayer oils to Islamic inmates of the DOD, just as you have with Keith? You not at this time.
Your Honor,
So
I would
have considered it. Maybe she has good reasons for not doing it, but they didn't consider it, right?
But Your Honor, DOC is only obligated to consider options that would also achieve its compelling interest and would alleviate the substantial burden. They're not required to consider options that doesn't achieve their compelling interest. And essentially, asking them to consider something that they've already rejected.
She didn't say that. She didn't say they'd already rejected it.
She did testify, though, later when it probed further about it, that that entering into such a contract on the stand, which I have to also point out that was the first time that this point was brought up, was when Mrs. Vargo was on the stand after, extensive litigation, 30B6 depositions, specifically deposing Ms. Vargo, that this would, she later was asked, further about that and said that this would not achieve the compelling interest because essentially they would be returning to a multi-vendor. Whether they have contractual relationships with them, that may solve some of the problems, but it wouldn't resolve all of the issues that she testified with that existed with respect to multi-vendors. I think that my friend on the other side
all of doing this one would be one other vendor. That's all we know about.
Well, Your Honor, she testified and the court gave credit to her testimony and experience as a prison official that one situation would lead to others. This is not viewed, in a vacuum. They have experience with and, do everything that they can to accommodate religious practice.
I hear you, I understand you, and I don't know that doesn't make sense, but didn't the Supreme Court tell us in Holt, the classic rejoinder of bureaucrats throughout history, if I make exception for one, I'll have to make one for another, so no exceptions? Didn't it reject
the fact of having multiple options?
That they never considered this? That's the problem. Maybe they can say we considered it and we are now considering it. We will consider it, but we are rejecting it for these 14 reasons. But they said
that's what we did. That's what we did in Greenhill, didn't we? In other words, we indicated that the least restrictive method could be raised during the prison process or even in the litigation, and could be rejected in the litigation itself based on the reasons that they have. And I think that's what was done here. The prison said they hadn't considered that because it wasn't within the scope of what they were trying to do. But when it was suggested to them, they explained why during the course of this litigation in the testimony. And in Greenhill, we said that's exactly what you're allowed to do.
So maybe you can direct me to the piece in the record extract where they explained why they had not considered it.
Your Honor, Ms. Vargo testified on direct both for the plaintiff and the defendant, so I understand that her testimony is scattered throughout the transcript.
So just tell me that, you don't have to give me, but just where she explained why they had not considered it.
Your Honor, I believe it's on JA 162.
162.
Yes, and she's asked, and if you were to enter into a contract as plaintiff's counsel suggested with a Muslim-based service or Muslim vendor in a similar fashion to the way you entered into a contract with Keith, would that necessitate similar contracts with other vendors?
But that's the,
Of
we
other
do it for one, we do it for everyone. And I just told you the Supreme Court says that's no good. Just for now, take that as.
Yes, Your Honor. But then she continues on to say, you know, basically then we're just contracted with multiple vendors and we're back to dealing with multiple, you know, it's not just the vendor ships it to the Department of Corrections. The vendor has a commissary window that operates inside the facility. They are employees that are inside each facility. The contract, you know, goes beyond you're responsible for selling and providing these items to the Department of Corrections.
Well, the question of whether they considered it, it seems to me, is it comes down to whether they considered a single vendor policy versus a multiple vendor policy, which another contract would involve. And before 2013, they had experimented with multiple vendors, and that had raised all kinds of problems. They testified to that. The trial judge credited that testimony. So I don't think it's necessarily whether they considered an Islamic, a particular Islamic compliant vendor. I think the question here is whether they considered dealing with a single vendor versus dealing with multiple vendors. And that goes to the heart of what the correction system did actually consider. And they didn't want to go down that road again. You see what I'm saying?
Your Honor, I do, and I agree that, you know, my friend across the aisle is trying.
That's what the issue is. And that is whether they can stick with a single vendor policy or whether they go with multiple vendors. There's been no complaint, and I think it would be a more compelling case if the oils in some way were not Islamic compliant. But I understand that the oils were Islamic compliant, were they not?
Yes, they were, Your Honor.
But under the religion, it has to be carried by an Islamic person. Is that right? I mean, is the other side making that up?
My understanding, and in the RLUIPA framework, it is Mr. Favor's personally held religious beliefs. And his personally held religious beliefs, I believe, are that he cannot purchase it directly from a vendor that also sells swine idols or alcohol or that take interest.
So they're procuring these oils from, I guess, the most well-known vendor is Halaleo, is it?
That is one vendor that's designated by.
They're procuring the oils from an Islamic compliant vendor.
Yes, and they're certified to that.
Yeah, I mean, the oils are Islamic compliant and they are procured from an Islamic compliant vendor. And I think that one of the difficulties here is that, you know, it's a lot of these prisons are very short-staffed, and they have screening they have one rule for religious publications, but the additional screening and for all kinds of other materials would impose a substantial burden. And I think that the level of trust that enables them to not have to engage in the most intensive screening comes from their extensive history with Keith. And given the things that can go wrong in terms of product quality and in terms of smuggling contraband, it seems what the prison is saying is that we're in a whole lot better situation just dealing with a single vendor whom we have experience with than multiple vendors whom we do not know and who don't have a track record. And that's what I always thought the issue was yes, they had tried contracts with multiple vendors. They had tried it.
But they hadn't had contracts. Am I misreading the record here?
No, Your Honor, that there were no established contracts with religious vendors.
Right.
But there were arrangements. I mean, there was materials that were supplied and there were materials that were paid for.
At a certain point prior to the implementation of the policy, offenders were allowed to order directly themselves from different vendors. Again, the policy is not, black and white. It evolved, not, as the court pointed out, not in a vacuum, over time. And each was in response to different security concerns that were raised. And I think that those security concerns and experience were credited by the district court when Ms. Varga was presented for the first time at trial. And I know that my friend on the other side disagrees and argues that he has raised this issue before. But I respectfully disagree. But that the district court found that when it was raised before her, that her experience and expertise, and as the representative of DOC and the history of the policy, informed her response to say this would not achieve those compelling interests. The idea that there is that much of a difference between multiple contracts with vendors and no contracts with multiple vendors, yes, that would alleviate some of the problems before, but it doesn't alleviate all of them.
Okay,
go to
where would I find that evidence? Around where in the JA?
Specifically, I mean, the district court itself.
Yeah, but I'm interested in the evidence, the testimony.
Again, I think that this is piecing parts of it together. I can't necessarily identify. I mean,
because you and
JA 162.
Don't that at one point she said, yes, we could consider a contract, and she talked a lot about the comfort they get from a contract with the group that they have, and we could consider a contract. But have we done that? No. We know that we don't disagree about that, right? But you're saying what she later says explains why they wouldn't do that in the future. Is that what you're saying?
Yes.
Okay.
I also, in that line of vein,
Page 161 on the whole explanation is that it would violate the multi-vendor policy and they'd be right back where they started from.
Yes,
that's the theory. And their multi-vendor policy was explained initially as to why they wanted that and not to return to it.
They assumed in the multi-vendor policy just what the Supreme Court said we shouldn't do, which is if you give it to one, you give it to all. So I guess it was multi, but
a question of picking out the Muslims and not picking out the Christians and not picking out the Baptists. And they said there were 40, she explained there were 40 different faiths they would need to enter into with that. And that would violate their multi-vendor policy. And it goes back to Judge Wilkinson's inquiry about really what we're talking about is the multi-vendor policy versus the single vendor I think that's where she explained it.
I would agree. I also have 2 points I just want to make sure to make. That at some point, during the course of litigation, point made in Greenhill and taken from Hobbs, where does that extend to at some point? Arguments made in closing briefs, arguments made in closing arguments. I mean, again, the standard under Holt is that they're not required to consider every conceivable option. They had a lot of experience with this and considered many of them. At no time prior did they bring up contracting with an Islamic vendor specifically. They did bring up at the deposition, which has not been made part of the record. It was a 30B6. It could have. Trial counsel did not. But there was briefing and questions. And even in their closing brief, which is part of the record, they refer to a one religious vendor that could meet the needs. In their closing brief, it's JA 403, no evidence that one large-scale vendor could not accommodate other religious beliefs other than that of Mr. Favor. That is in direct contradiction with what Mr. Favor is saying would alleviate that burden. If it was one religious vendor that provided all religious items, so separate than Keith, they're still selling idols, according to Mr. Favor's own testimony, which brings me to a second point, is that nowhere in the record does plaintiffs say or they establish that a specific contract, as the one suggested, would also alleviate the substantial burden or that resolves the problem.
Well, what you're saying at bottom, it seems to me, and I think this flows from the record, is that the question and the different options, and to a degree, these are independent of whether there's a contractual relationship or not, is the question of whether there should be a single, whether the correctional institution is entitled to deal with a single vendor, or whether they need to go the road of multiple vendors. And all they're saying is that the multiple vendors presents us with a whole host of problems. And that's something that it seems to me that the district court listened to and heard extensive testimony on the problems that a policy of multiple vendors created. And that would be independent of a contract. You could have contracts with a whole lot of people, and it wouldn't alleviate the problems that arose with multiple vendors, which the VDOC had already experienced. Isn't that correct?
That is correct. Well, the specific, as Judge Botts pointed out, that they had not experienced specific contracts that are the same as Keith's with these vendors, that problems would still arise. You'd have to have multiple commissary windows. You still have then multiple deliveries coming in, multiple vendors to check. And the contractual relationship is not just built on experience, but the terms of the contract, which, having that with two or maybe more, even under no slippery slope, argument, under just this case alone, it may be that, I'm sorry, I see my time has expired. May I finish my point?
Yes, please do.
That, the plaintiff here, Mr. Favor, says that he cannot purchase religious items. He actually says all items, but that they're stricter when it comes to religious items from a vendor that provides, as I said, swine, idols, alcohol, or that takes interest. While one vendor that they suggest might be appropriate for oil, they might not sell prayer rugs or kufis or other religious items that he has already stated that he needs.
Let me ask you this. If a family member or a close friend visited him in prison and purported to gift him with some holy oil that the friend or the family member had purchased from an acceptable outlet, would the prison allow that?
No, Your Honor. The only donations to be made are through Grace Inside or Muslim Services, which is contracted, partially paid for by the Inmate Commissary Fund, which is a commission or part of the sales from Keefe that funds it. They provide not only religious services, but they also will accept donations, and there's a list of items that they will accept donations, but those, they can't be given to any specific offender. And that is another issue that was sort of addressed by the vendor policy, is that there's anonymity between the vendor, whether it's Keefe, and the person ordering it, to decrease the chances of, contraband being entered into the facility.
All right, thank you, counsel. I'll ask Judge Niemeyer, do you have any further questions?
No, I'm fine, thank you.
Judge Moss, do you have further questions? All right, Mr. LaPierre, you have some, I think you have, there are multiple counsels here. Are you the one that's up next?
It's just myself, Your Honor.
Okay, go ahead.
Yes, Your Honor. I want to address the first point, and I believe my counsel, Ms. Cahill, my co-counsel, Ms. Cahill, may have pointed out herself. The argument has been made that the alternative proposed was proposed for the first time in questioning at the trial itself. However, I would point the court to the
You're frozen. Can you hear me?
He's frozen. He's frozen. Here he comes.
Now he's off. Now he's okay.
Am I back, Your Honors?
Yeah,
Yeah.
you are.
Mhm.
I apologize. I just wanted to point to the reply brief we had putting forth in this case as quotes to or cites to the three places wherein we did actually raise that in depositions with the witness prior to the trial itself. The issue here, Your Honors, is that the defendant had a policy wherein individual inmates were allowed to independently order out from multiple vendors of their choice any item that they wanted prior to the institution of a single vendor policy. That created some problems that were well laid out. In response, the defendant instituted a single vendor policy where all items, regardless of type or source, must come from a single vendor without consideration of a lesser restrictive alternative of entering into contractual arrangements with a single vendor and then a vendor that meets the requirements of Mr. Favor's religion. While it was asserted that Mr. Favor has a personal belief, it is a belief of the type of religion he has, a Orthodox Sunni Muslim religion, that the items must be purchased from a halal vendor to maintain halal status. They never considered it, they never rejected it, and in the trial itself, the only thing they said is that once you make exceptions for one, you tend to have to make exceptions for others, which is an unacceptable reasoning.
Well, she went much further than that because on, I don't know if it was your examination, but on her cross-examination, she talked about the need for finding a Muslim supplier. They would have to investigate the supplier. They would have to pick a contract with a particular supplier and enter into that contract. And they would have to do that on each request. And the question, she said, all of a sudden we're now a multiple vendor situation where we'll have to investigate that person, and we have multiple persons coming to the door. I mean, she went into that some length, basically saying that it takes them right into the risks that were present in a multiple vendor situation.
She did state that there would likely be other people who would make their requests and they would have to investigate and select vendors. However, she did admit that they could enter into contractual relationships with these vendors, that it is the contracts that give them comfort and address the safety, security, and cost concerns with Keefe, and that the
Well, it's
contract.
not only the contract, they talked at length about the relationship they have with Keefe.
The problem is that the problems are not an outgrowth necessarily of a contract or the absence of a contract. It's the experience that you have that gives you confidence with the parties that you contract with. Any business is likely to have contracts with 2 or 3 or 4 different people. And they have confidence in some, and they don't have confidence in the other. And the problem is the multiple vendors create all kinds of staffing problems and scrutiny problems and the rest. And as I say, the people who, the Department of Corrections, like so many other businesses these days, are short-staffed in many instances. And there's a large quantity of illicit materials that can be smuggled in under the guise, well, this is just a religious item. And it seems to me we're loading a real burden on the back of the institution when we throw the institution back into a multiple vendor policy, which there's extensive testimony about all the problems that created.
Yes, Your Honor. The issue is that all the testimony and all the problems that were created were where there was multiple vendors chosen at random by the inmates at an individual basis in individual facilities without any contractual arrangement or any prior approval. We do not have a problem with the fact that there are approved sets of religious oils that you can get, only those. We do not have a problem with the fact that those items have to go through security and be delivered to the inmates by key fee run commissary personnel. We don't have a problem with the fact that that order has to go through a commissary system and is independent or anonymous to the vendor. The issue is they never considered and rejected entering into a contractual relationship with a religious vendor as a less restrictive means than a pure single vendor relationship. And that
they did consider it when you raised it. And I keep pointing out to our prior decisions that say it doesn't have to be historical because they don't know about your complaints yet. They have to be able to respond to your complaint during the prison proceeding, during the deposition, and at the trial. And we said at any one point, those considerations have to be taken into account. And you did bring it into account, and she did respond to it. So the question is, was that response adequate, and was the fact finding sufficient? But I think it's a ghost issue of that it had to be raised some point in time in history before this proceeding. That's just not so.
Yes, Your Honor. And she did state that they had not considered it. And then when she considered it at the trial, her concern was that you'd have to make more exceptions and then that they would be in a multiple vendor position, and cited back to concerns that they had related to uncontracted, unapproved, multiple vendors that just had none of the contractual relationship or
she talked about the investigation. She talked about you couldn't just go to one contractor. You'd have to go to other Islamic suppliers, and you'd have to evaluate them. And you'd have to do this for anybody who requested it, because now this request is being made. The prison doesn't want to assess the religion aspect. It would have to go through this religion committee. But all this was explained. And the question is, you can argue, I think, that this reason is not sufficiently responsive to the religious practice. But the whole notion of whether it was raised and responded to, I think it was. It's the record, the whole record basically addresses this. Halalco's name came up dozens of times. Everybody's talking about enter into Halalco with this, and she explained what the reasons were. Now, if they're not sufficient, that's really what we're addressing on this appeal. But I'm not sure we should get stuck on whether it was raised in deposition or was raised in the past. They responded to it when you presented it to them. And the question is, was that adequate? And the answer is what we have to decide. And the district court did decide it. We just have to decide the district court is correct.
Counsel, there's one other point to follow up on what Judge Niemeyer said, and that is, if you have a contract with an Islamic compliant vendor, that still doesn't resolve all the problems. It may not, because there's no guarantee that the Islamic compliant vendor is going to be selling all the different religious materials that inmates may want. And that's true with any religious faith. One, you can have a contract with an Islamic religious vendor, and there would be, say, well, you may be supplying prayer oils, but you're not supplying this, and you're not supplying that, and you're not supplying that. So in order to meet all those needs, you start saying, well, I have to have contracts with this. And what they're trying to say is both, is simply at bottom that the multiple vendor situation doesn't work. Now, Judge Niemeyer says you don't need a historical reference point, and I think he's correct on that. But in this case, they do have a historical reference point, not with the precise thing you're talking about, but with multiple vendors and the problems that that gives rise to. That seems to me what the basic question is.
And Your Honor, our position was, aside from the burden shifting issue, which was a separate one, was that they had not raised sufficient evidence or any evidence that there would be any insufficiency in halal code, because halal code provides the items that he needs, the prayer oils and the kufi, or that there had been any evidence related to any other religions that did not find the Kifi commissary acceptable.
All right, thank you.
Thank you, Your Honor.
Judge Niemeyer, do you have any more?
Thank you.
Judge Motz. All right, we thank you. Thank you both. I'm sorry we can't come down and greet you, but we want to thank you both. And we will proceed into our next case.
Thank you, Your Honor.
You're on mute.
You're on mute.
I don't show that you're muted, Mr. Reisner. Can you check something else with your settings possibly?
Apologies.
Thank you.
Good morning. Jack Reisner appearing on behalf of the Pennington class, and if I may, I'd like to address the claim regarding Scanner's liability, and then Mr. Urkel will address Fluor's duty to provide a timely warn notice.
Can you talk a little louder? Maybe. Yeah. Okay, thanks.
Certainly. Is this better, Judge?
Yes.
Thank you. And Mr. Urkel will address Fluor's duty to provide a timely warn notice, and we have requested 5 minutes for rebuttal. May it please the court, the issue on appeal is what standard should be applied when determining who is the statutory warned employer in the case of a plant closing where there are several employers at the site. Should it be the direct liability principle based on which employer's actions caused the violation of the WARN Act, or should it be the integration principle, which looks at whether the employers, when they were operating, were doing so as one company? Under the WARN Act, there is an appropriate setting for each of these rules. So the facts matter, and the facts here dictate that the direct liability rule as framed by this court in Johnson v. Flowers applies. For it tells us that the statutory employer is the one that controlled the employment practice that violated the employee's rights. This principle was essentially incorporated a year after the decision was issued into the WARN Act, and its regulation tells us that this rule specifically applies to contracting companies and they're independent contractors, which the appellees were here. And so I think the facts are important, and I would like to summarize them if I
Well,
may.
I think you start off with a very provocative statement of what you think the principles are. It seems to me the WARN Act imposes a duty on an employer to give notice to its employees. And the question is whether the employees of contractors and subcontractors also are employees of the owner. And the Department of Labor has given circumstances where you do go across the corporate form, those factors, so as to make employees of the subcontractor or the contractor de facto employees of the owner. But I don't think you can state it so broadly as somebody who caused a shutdown has to give notice to all employees at the site. I mean, that's not even the criterion is an employer has to give notice to his employees. And that's the general rule. And so the question you have to demonstrate is whether employees of other companies are de facto employees of SCANA in this case. And I think the Department of Labor has focused on its factors, which seem to be what everybody's applying. And to spread the rule, the fact that SCANA closed down the whole site means that every single employer at the site who was caused to lose a job has to notify every employee. It's just way beyond the statute and way beyond the regulations. You have to start with employer-employee relationship. That's the statutory relationship where a notice has to be given. And to get beyond the employees of that company, you have to have de facto employees, some kind of corporate veil breaking through the factors the Department of Labor have done. And I think it would be more helpful if you stick with that structure than some notion of, I'm not sure what it was with anybody who closes down the site has to take care of every employee in the site.
Your Honor, the starting point is absolutely correct that the WARN Act does look at the general case of one employer on a site. The question
It doesn't talk about a site. It talks about one employer giving down notice to another employee, to its employees when it closes its business. And so it's not geographical, it's a relationship. And I know your brief and your argument tends to make it geographical. They're all at the same site, therefore you have to give them notice. That's just not supported by anything in the statute or the regulations.
Your Honor, the WARN Act requires that an employer shall not order a plant closing without the requisite notice. And at section 2101A2, it defines a plant closing as a shutdown, which results in an employment loss at the single site of employment for which there must be 50 or more people. So the WARN Act is very site specific.
It's site specific, but it's also specific to employer-employee.
As the starting point.
The employer-employee is the starting point. We know what that is generally.
Right.
So the question is, if the employer has its own subsidiaries performing it, then it's in real danger of having to give notice not only to its own employees, but its subsidiaries' employees because of the various factors. Here we have owner, contractor, Westinghouse, and subcontractor Fluor. And so the case you have to make is, why does SCANA have to give notice to Westinghouse employees and Fluor employees? And to get to that point, it seems to me you have to follow the Department of Labor's criteria, right?
Yes. And the criteria includes independent contractors and contracting companies specifically. And this,
so long as they contribute to the notion that the employees are de facto employees of SCANA.
Correct. And Your Honor mentioned the piercing of the corporate veil principle, which is important.
Well, it's not. That's the common law. The Department of Labor has its own, which are more adapted to the WARN Act.
Yes, and it adapted Johnson v. Flowers, this court's decision in Johnson v. Flowers, it adapted in which the principle, whether you call it common law, you call it federal common law, it is the WARN law. And it incorporates the idea that the employer that orders the specific violation is the responsible employer. And Your Honor's concern about this principle spreading to any and all situations of a plant closing is understandable, but the context of Warren is so specific to what has to be in place for it to apply in the first place that often is the iceberg that's beneath the waters that most observers do not pick up, which is that in order to be in the place that SCANA was vis-a-vis these independent contractors, they had to be on that site, living on that site, and with facilities on that site for the long term, in such numbers that we're talking about only the largest employers in America, over 100 employees, which excludes every other garden variety, plain vanilla
Does
independent
SCANA even
contractor.
know who the floor employees are?
Excuse me?
Does SCANA even know who the floor employees are?
They don't have to know. They have to know where Floor's CEO is. And to have told the CEO, we are going to be shutting down in 60 days, whenever it was, that would have changed the whole complex of this
I'm in
case.
court.
SCANA does not have to deliver its notices to the Floor employees. It has to tell Floor we are shutting down, and that immediately shifts the burden to Floor as the independent employer who has the capacity to make a decision to give its own employees a notice, and that takes SCANA totally off the hook, and that's what happens in business. That's what the record says here. Floor never saw anything like this. There's going to be a meet and confer. There's going to be a consultation in which Floor has the independent duty to give its notice.
No,
Had that happened, we
thing-
would not be here.
One
It didn't
thing,
happen in the extraordinary
Counsel-
case. Sorry.
one thing that Judge Niemeyer mentioned was the DOL regs, which other courts have followed and which seem to be highly pertinent. And they have a list of 5 factors, and you were very selective about that. And you've emphasized factor number 3, which was de facto exercise of de facto control. But unfortunately for you, it's only one of the 5 factors. And the other ones, which were common ownership and common directors and officers and supervision and who paid and who fired and who trained, all of those cut against you. And even on the one factor that you thought cut in your favor seemed to me to be directed at a parent-subsidiary relationship, which is absolutely not present here. So the question we have is taking these DOL regulations, applying all 5 of the factors as the district court did. And I just don't see how you prevail on those kind of things without expanding the scope of this statute to quite an extraordinary extent. And that's the DOL regulations are controlling here, and they cut against you. And the one that is even arguable cuts against you. How do you overcome all that?
2 things, Your Honor. First, the DOL does not say all factors have to be considered or even met. These are non-exclusive. However, the DOL added the direct control factor with the Warren Act, unlike every other statute, because a year before Johnson v. Flowers identified the direct liability rule, which is pertinent to a plant closing like this. And so the Third Circuit has recognized, as have other courts, that the de facto control is unlike other factors. It is preeminent if there is clear evidence that one decision has been made that has been applied to whether it's a subsidiary or the contractor. That decision controls, and there need not be any other factors shown.
Well,
there is overwhelming domination by one company.
The direct control rule is when a parent is directing the operations of a subsidiary, and you don't have that.
It directed
The direct control rule did not purport to sweep in every subcontractor and every independent contractor that might have some connection to a work site.
the direct control in the decision to shut down was SCANA telling Fluor, get yourselves off this site, shut down your facilities. You must do that now. That is direct, total domination and control over these contractors with respect to the very thing that Warren wants, which is to see 60 days notice before that happens, and caused a prima facie violation for Fluor and Westinghouse, for which they have sought affirmative defenses.
I thought you were complaining about the fact that SCANA did not give notice to the employees, not to the companies.
It's the same thing when they are giving them, when they are
It's
giving
not the same thing. The duty is imposed on the employer to give notice to its employees.
Yes.
Of 60 days notice, or to pay them during that time. But that's an employer-employee duty. And so the fact that Fluor is on there with 4,000 employees, you're suggesting SCANA has to give notice to Fluor's 4,000 employees.
Not if we consider the dimension that the single employer rule presents in the act, which is that the independence is the issue that we look at. And independence, which is the Department of Labor rule, which the defendants have not even mentioned in their briefs because it undermines their case completely, and which the district court did not focus on. This idea of independence is the critical rule, which the factors are there to help us consider. And the independence would have been provided by SCANA to Fluor had they told Fluor we are shutting down, which shifts the Warren burden to the direct employer in that case, in this extraordinary circumstance where—
All right, thank you, Mr. Reisner. Your time has expired, but you do have some rebuttal time, and we will look forward to hearing from you then.
Thank you, and I'd like to ask Mr. Urkel, if I may, to complete the plaintiff's case.
Okay. Is it Mr. Urkel?
Mm-hmm.
Please proceed.
May it please the court. My name is Charles Urkel. We have appealed the district court's grant of summary judgment to Fluor on multiple grounds. Initially, the court should reject Fluor's contention that it's not liable as a matter of law. Even if it was entitled to the UBC defense, before it can invoke that, it must give as much notice as is practicable, even if that means giving it on the last day or the day of the shutdown. So if you take Fluor's argument at face value that they didn't find out until July 31.
Well, I realize this is on summary judgment, but at the same time, Judge Childs was very familiar with the record here. And she did indicate that they had given notice as soon as practical by mailing Warren notices within a few days, and that before the closure, they were in the dark, that, as is often the case, SCANA didn't want Fluor or other independent contractors with whom it was dealing to know all the ins and outs of its financial situation. And you have what seemed to be a pretty well-reasoned district court opinion in the case, which I recognize was in summary judgment, but on the other hand, Judge Childs has lived with this case and with this record for a long time.
Well, her opinion focused significantly on the unforeseeable business circumstances defense as it pertains to Fluor, but when she said that the notices went out in a few days by August 4th, that was incorrect. In Fluor's own motion for summary judgment and in Ms. Carty's—
I thought it was August 8th.
No, well—
Didn't they mail them out on August 8th?
They said between 8 and 10, they went out in batches by first class mail. Yes, that means people didn't get them till the 10th, 11th, or 12th. And then they acknowledged 7 days later on the 16th, they sent a second notice to the craft employees, the 3,000 craft employees, because there had not been contact information and a name in the earlier notice. They said, thank you for your patience, thereby acknowledging that the earlier notices were not effective. We still don't understand why they didn't send them out at the same time they sent the government notice. It's a one-page notice. It was sent out on
Well, I
August.
thought they had to get together, they had to get the information together, prepare the letters and stuff them in envelopes, but they also needed information. Didn't they have to collect that?
They had everybody's email address on the July 31st. These employees almost all had Westinghouse and Fluor email addresses because they had worked for both entities. They all had email addresses, which is exactly how they sent it to the state and local officials. So it's curious as to why they didn't give it out to people as they were walking off the site. They instead gave this thing called an FAQ, which is clearly not suffice for a warn notice.
All right, thank you, Mr. Urkel. We appreciate that. All right, is it Mr. Ty or Mr. Speth?
It's going to be Mr. Speth, Your Honor.
Mr. Speth, excuse me, I've mispronounced your name. All right, please proceed.
May it please the court. I'm Ted Speth. I represent SCANA and SCE&G. I'll address during my allotted time the relationship between SCANA and Fluor and SCANA and Westinghouse as it relates to the issues in this case. Mr. Ty will follow me and he will address two issues. One, a waiver issue, which now exists in this case. And secondly, the timeliness and the appropriateness of Warren's notice to all the employees it chose to lay off. Appellants are asking this court to abandon the single employer analysis as established by the plain language of the Warren Act, the Department of Labor regulations under that act, the case law over the past 2 decades. Instead, they urge this court to adopt a new analysis that has not been applied in any setting by any court under Warren or any other employment statute. To sum up what Judge Childs did, she used the traditional approach of looking at the 5 Department of Labor factors. She looked at the cases that have been decided over the last 20 years, particularly post-Pearson out of the Third Circuit in 2001, and she construed all 5 factors, looking at them independently, and reached the conclusion that the appellates had not shown a single employer relationship, failing to show one single factor in their favor. Now, appellants, instead of relying on this traditional single employer Warren analysis used by Judge Childs in courts over the last 20 years, have pivoted. And now they proffer 2 never used theories in an attempt to claim SCANA was a single employer with Fluor and Westinghouse. Both theories are predicated on the decision maker direct liability analysis. Although this analysis has been recognized and used by courts in other settings, it has never been used in the manner now requested by the appellates. The appellate's first theory is that the DOL single employer test is really a 1-factor test, not a 5-factor test as promulgated by the Department of Labor and used by Judge Childs and other courts. According to appellates, the only factor that needs to be established to have a single employer relationship is that of de facto control. And only essentially it ignores the other 4 factors that courts have analyzed over the decades. Appellates then assert that the unlawful decision on the Warren was SCANA's decision to close the construction site, and that act alone satisfies de facto control, thereby making SCANA a single employer with Fluor and Westinghouse, according to the appellates. Now, their second theory is similar to their first, but they abandon the application of DOL factors altogether. Appellants urge this court to recognize the decision maker direct liability analysis as a standalone test for a single employer relationship, thereby ignoring the DOL factors altogether. Now, the pertinent facts of this are as follows. Involved are 3 Fortune 500 companies that have vastly different business pursuits from one another, operated completely independent of each other, and whose only contact was vis-a-vis arm's length business dealings related to the VC Summer construction project. It's admitted that SCANA made the decision to cancel the project effective July 31st, 2017. Upon that decision being made, each of these three Fortune 500 companies independently of each other decided, first, which employees they were going to retain, second, which employees they were going to lay off, and third, what their respective obligations were under Warren regarding their employees. For instance, SCANA made the decision that it would continue the employment of the 617 SCANA employees it was going to lay off for 60 days after notifying these employees of their layoff on July 31st, 2017. Fluor and Westinghouse, on the other hand, completely independent of each other in SCANA, made the independent decisions as to what their obligations were under Warren regarding or relative to the employees that they had selected for layoff. In short, SCANA was responsible for its employees, Westinghouse was responsible for its employees, and Fluor its employees, just like this project had proceeded from the beginning. The fallacy of appellant's theory is threefold. First, the DOL regulation set out a 5-factor test, not a 1-factor test. Second, the decision maker rule has never been applied to impose liability in any relationship that was not a parent subsidiary, or in rare cases, a lender borrower, when that relationship had actually morphed into what appeared to be more like a parent subsidiary relationship. This was Judge Child's conclusion in her order, simply that an arm's length business relationship does not establish de facto control. Appellant's third fallacy is what constitutes potentially unlawful conduct under Warren. The potentially unlawful decision under Warren is the decision not to provide 60 days advance notice to those employees selected to be laid off, not the decision to cancel a project as asserted by appellants. There is no claim that by the appellants in this case that SCANA should or even could have notified them 60 days before they're being laid off by Fluor and Westinghouse, which makes sense given that they had no employment relationship with SCANA whatsoever. Now, I want to address two cases that the parties rely upon fairly heavily in their briefs. First is Pearson versus General Electric, and I mentioned it earlier. It's a 2001, Third Circuit opinion. And since that decision, it has been recognized virtually universally by courts to be the sentinel a single employer decision under the Warren Act. The Pearson court addressed two issues. The first issue, what test should be applied under Warren to determine if there's a single employer relationship? The second issue, when or even if two corporations that are not a parent subsidiary can be held to be a single employer. Now, there are three takeaways from the Pearson court's decision that are applicable to this case. Number one, the 5-factor test of the Department of Labor is to be applied in single employer Warren cases. Two, it is very difficult, if not impossible, to establish a single employer relationship without ownership interest. And three, de facto control is one factor to be considered out of 5. In fact, according to the Pearson court, de facto control is to be used, and I quote, to tip the balance in an otherwise close case, end of quote, and that quote can be found on page 490 of the Pearson decision. The appellant's position is in opposite of each of these three holdings by Pearson. Now, the appellants in their brief rely on the Administaff case, which is a 2003 decision from the Fifth Circuit Court of Appeals. In Administaff, TCS was the direct employer of the employees in question. TCS owned the plant where the employees worked. TCS operated the plant where the employees worked. TCS made the decision to close the plant. TCS decided to lay off the employees. Most importantly, TCS decided not to give the employees it chose to lay off advance notices required by Warren. Now, Administaff was merely and had an arm's length business relationship with TCS to provide certain services at that plant. It was not involved in any decisions related to the closing or any of the decisions relating to the layoff, including the decision not to provide Warren notice. The Fifth Circuit, using the 5-factor analysis, just as Pearson set out, found, just like Judge Childs found, when you have a completely arm's length business relationship, that none of the factors were in favor of a single employer relationship. To the extent that admin staff applies to our case, it supports SCANA, not appellants. In closing, the traditional 5-factor Department of Labor analysis is an appropriate test for this court to apply, just as Judge Childs did and other courts have done for decades. Under that analysis, appellants cannot establish that SCANA was a single employer with either Fluor or Westinghouse. Recognizing this truism, appellants instead ask this court to create an entirely new test, which is contrary to the Department of Labor regulations and the entire body of the controlling case law. This court, just as Judge Childs did, should deny this request. I appreciate your time, and I'm glad to answer any questions the court may have.
Thank you, Mr. Spaeth. Judge Niemeyer, do you have any questions?
No, that's fine, thank you.
Judge Motz?
No.
All right, thank you, sir.
Thank you.
Mr. Ty?
May it please the court, my name is Haygood Ty, and I'm with Fisher Phillips, and we represent the Fluor appellees. In the lower court, Fluor moved for summary judgment on 2 separate and independent grounds that are relevant to this appeal, and on both of those, Judge Childs granted summary judgment. Fluor asked this court to affirm for 2 reasons. The first, which I refer to as the waiver reason, relates to the fact that the appellants waived the first ground on which Judge Childs granted summary judgment. And the second reason is what we refer to as the no competent evidence reason, and that relates to Judge Childs' ruling on the unforeseeable business circumstance defense, which we refer to as the UBC defense. If this court agrees on either ground, then Fluor's dismissal should be affirmed. With respect to the first reason, the waiver reason, Judge Childs ruled in the lower court that the appellants had waived an issue, and the issue was this: Fluor moved for summary judgment on the grounds that the statute says that only an employer who orders a closure should be held liable. In response to that, the appellants provided no response to that at all in the lower court, and as a result, Judge Childs found that they had waived that argument. She then went on to grant summary judgment to Fluor on the merits of that argument. Now, and she also noted in footnote 26 that they probably chose not to challenge that, because if they had challenged it, it would have required them to take positions that were inconsistent with other legal theories that they were pursuing at the time. Now, when we move to this court, the appellants waived this issue again. They did not include this on their statement of issues on appeal. They also did not address this in their opening brief to this court. And under the well-established case law of this circuit, if an appellant fails to follow the federal rules of procedure and preserve the issue, then the issue is considered to be abandoned. And that's true even when, as it occurred in this case, that the appellants addressed the waiver issue for the first time in their reply brief. So because the appellants have waived this issue twice, once in the lower court and the second time in this court, Fluor respectfully requests that its dismissal be affirmed. Now, because these are alternative grounds, Fluor's position is that because of the waiver issue, they may not even need to rely on their UBC defense, but I would like to address that as well in response to Mr. Urkel. With respect to the second reason, and this relates to the UBC defense, the appellants have been unable to point to any competent evidence, and that's why we call this the no competent evidence reason. They're not able to demonstrate a genuine issue of material fact to justify overturning Judge Childs' ruling that the notice was issued as soon as practically Fluor's 4,000 employees. Now, the appellants did not appeal that it was unforeseeable to Fluor. So the only issue related to this defense is whether or not the notice was issued as soon as practicable. Everybody agrees that, and the appellants concede, that Fluor did not learn of the closing until July the 31st. So they couldn't have given 1 day's notice or 60 days advance notice. Instead, they respond and make what I would characterize as two unsupported compliance arguments, one with regard to the timing and the other related to the content. If we look at the WARN Act itself, at the statute contemplates advance notice. The idea being that employees should be given time to prepare for a layoff, that they should be given notice ahead so that they can get retraining, look for another job, things of that nature. The statute itself does not contemplate, and in fact doesn't even mention after the fact notice. But when an employee receives after the fact notice, they already have, as they did in this case, the most important information, which is that their site is closing and that their jobs are being lost. So with the spirit of the WARN Act in mind, the appellant's argument seems overly technical and, as I will explain, is not supported by record evidence. In the lower court, at the summary judgment phase, the appellants did comment that Fluor could have issued its after-the-fact WARN notice sooner, but they offered Judge Childs no facts at all to support that statement. It was a one-line statement in their brief. In this court, they argue that because Fluor is a big company, that perhaps it could have or should have or might have done something faster. But conclusory allegations of this type are not competent evidence, and we have not heard the appellants point to any evidence to suggest that Fluor could have issued the notice a day sooner, 2 days sooner, or even an hour sooner. And that's because the only competent evidence, the only evidence in the record at all regarding Fluor's effort to get the notice out as soon as practicable is found in the, in the declarations of Ellen Carty, who was the director of HR on the site, and Michael Philpott, who was the manager of human resources on the site. And the appellants did take a 30B6 deposition of Michael Philpott on the topic of WARN notice, and they elicited no testimony at all to suggest that Fluor had done anything other than issue the notice as soon as practicable. So there's no evidence in the record that Fluor was negligent or intentional in any sort of delay at all. Instead, the record demonstrates that this was a very chaotic time, a very disruptive time. The Human Resources Department was escorted off the site with everybody else, had to go the next day and set up temporary HR offices with loaner laptops and things of that nature because they were not allowed to go back on site and retrieve their information, their computers. And despite all these challenges, within a matter of 3 or 4 business days, Fluor's HR department still got these enormous WARN packages put together and provided to their third-party vendor. And the vendor then took and printed and stuffed and mailed those within 2 business days after that. Now, the appellant's speculation seems to suggest that they think Fluor should have issued the notice as soon as humanly possible, but as soon as possible is not the standard. The standard is as soon as practicable. And Fluor has carried its burden that it did do that it did issue the notice as soon as practicable, and the appellants have failed to produce competent evidence to the contrary. Now, the appellants have tried to raise a compliance issue over the lack of an additional telephone number in Fluor's notice packet. Respectfully, Fluor does not believe there's any violation there at all. The cover letter to the WARN package included Ellen Carty's personal email address. The appellants contend that a phone number should have been included, but they seem to disregard the fact that the package had many telephone numbers, including, and I'm holding up JA4226, which is a page that was in the WARN package that includes 10 different telephone numbers that employees could call to get more information. And those were not the only telephone numbers in the package. There were other telephone numbers to call about unemployment or to get a hold of the company's employee assistance hotline and things of that nature. So there were certainly plenty of telephone numbers, and clearly Fluor complied with the regulations. But even under the appellant's theory that Fluor did not, the regulations specifically say that these types of inadvertent errors, which we don't believe it was, but even if the court should determine that, the regulations say that those were not intended to be violations of WARN. So in conclusion, having waived the first ground on which Judge Childs granted summary judgment twice, we would ask that the court affirm on that basis. Alternatively, we would ask the court to affirm that Judge Childs was correct in her order, that Fluor issued the notice as soon as practicable. And if the court upholds based on either of these reasons, then we would request respectfully that the court affirm summary judgment. I'd be happy to answer any questions that the court may have, and I appreciate you considering Fluor's argument.
Thank you very much, Mr. Ty. We appreciate that. If there are no further questions of you, I think Mr. Reisner is on now for rebuttal time. Is that correct?
Yes, Your Honor.
All right, please proceed, Mr. Reisner.
Thank you, Your Honor. The appellee's position fails for three very important reasons. The least of which is that, contrary to what's represented, we have not abandoned the other issues, the integration issues. As we've addressed them in our briefs, the integration at the site was extraordinary. One hand could not do work without the other hand. It needed three hands to do the work. It needed a brain, it needed muscles, and it needed someone who's going to look over and with discipline and make sure that it's going to be done right. Those were Westinghouse, Fluor, and Scanner respectively. So if there was ever a case where there was a meshing and integration necessary to do work, this site is the exemplar. Second, Your Honor, Your Honors, the idea that we should use the 5 factors as a checkbox list, a tic-tac-toe board, was decried by several courts, including first, this court in Johnson v. Flowers with Judge Wilkinson's decision, which said in the footnote, we will not apply that kind of a test to determine who is the statutory employer under the Age Discrimination Act. We will instead look to see who controlled the employment decisions, and the decisions are the key to what's being looked at. And other courts have followed that, the Fifth Circuit, the Second Circuit, the Seventh Circuit. 3 circuits have interpreted the WARN Act's 5 factors as telling them that they should look to use the de facto control factor to determine who made the WARN Act decision and whether that decision usurped any other decision-making from any other employer on the scene. And in each of those 3 cases, the Fifth Circuit in Administaff, the Second Circuit in Japone, recognized, and as did the Pearson courts, recognized that when you have a decision made about the WARN decision, which precludes any other decision-making by the immediate employer, then that decision-maker will point to liability as explained in Johnson v. Flowers and in the Huckel case, which followed.
In this case, SCANA elected to continue to pay its employees, didn't it?
Precisely.
Could SCANA tell Fluor to continue paying its employees?
No, it couldn't. It had to take Fluor's employees as they came, as WARN plaintiffs.
Well,
you have to take your defendant as they come.
That sort of indicates a lack of control altogether, because if it controlled the employees, it could say, okay, you're continuing to stay on. Our policy is that everybody on this site will stay on and get paid. But Fluor made a different decision because it controlled the employees, its own, and decided that it would not go that way. Actually, it decided it would be a hybrid, didn't it?
Your Honor, I'm not sure what they decided, but I'm not.
Well, they decided, the record shows. They retained some people and they let some people go and that type of thing.
WARN's control, Your Honor, is looking at the scene 60 days before and up to the layoff. At that point, SCANA could have controlled Fluor if it had come to Fluor as what normally would happen and said, we are planning.
SCANA decided it was not needed to provide notice by retaining the employees for 60 days. They paid their own employees.
I know, but your question, Your Honor, was a good one.
Whereas if the Fluor employees were under the de facto control of SCANA, then SCANA's ruling should have applied to them also.
SCANA should have broached the subject with Fluor at some point before determining
this is not an intercorporate question. This is a question of whether Fluor's employees are under the control of SCANA. And you said they are. And I'm suggesting if they were under the control of SCANA, then SCANA would have been entitled to decide that the employees keep working.
After they shut down the site and sent the employees to their fate, SCANA couldn't do anything with respect to Fluor.
Mr. Reisner, I have no problem with the de facto control test because it's one of the factors in the DOL, and we did say that in Johnson. But the problem I have is I don't see that there's a de facto control exercised here. It's not a subsidiary. They right after this contract ended, Fluor went on and took on some number of independent projects. And in terms of the, there's no common directors or officers, and in terms of the employees themselves, they weren't paid by SCANA, they weren't supervised, they weren't trained, they weren't hired, they weren't fired. So I don't have any problem with the test in Johnson v. Flowers. It's just that I don't see the de facto control here, and I just don't believe that the DOL regulations or anything wants to sweep every independent contractor, every subcontractor, or every business entity that has some connection with a construction site under this WARN Act. The simplest way to do it is to have the employer who employs the actual employees give its employees the WARN notice. And that is just simply to have SCANA give its employees the WARN notice and Fluor give its employees the WARN notice, and the same with WEC. And that seems to me to avoid the sort of endless confusion that would result when there's people throw up their hands and say, oh, well, it's not clear whether we're a single employer or not. If you have a rule that's easy to follow, which is tell your own employees 60 days before you're going to close the plant. That's something everybody knows how to do without scrambling it all into this complex equation of when is somebody a single employer and when is it not? And we'd be off on our own path this way too, because I don't think most courts have headed in that direction. That's a problem that I have, is we're trading in a certain degree of understandability and comprehensiveness and simplicity for something that's very complicated.
Your Honor, it shouldn't be complicated, but SCANA caused a problem in letting Fluor decide whether to give 60 days notice to its people. It didn't allow it to do that. It precluded that by keeping its plan secret. If Your Honor is correct, 60 days before SCANA told Fluor, we're going to shut down. What does that mean? We each have to give our employees a WARN notice. But SCANA purposefully precluded that by making the shutdown announcement as it was happening so that Fluor could not give 60 days notice. And that is the problem with the analogy that you've made, is that floor can't, nor should it necessarily have to give 60 days paid leave because it didn't make the violative decision of closing down that plant. SCANA did, and SCANA knew, and it looked into this and said, do we have to give our independent contractors their notice? And they came out with it wrong. They put the employees in a free fall, and they should have given for the ability to give 60 days notice. Absolutely. And that's plain as day in this case, which is why this is a textbook for what a SCANA should do. It should, if it is planning to close down, give notice to its
Your whole argument seems to
contractors.
suggest that SCANA had a duty to floor to enable it to give notice. And the WARN Act, your argument, I thought under the WARN Act was that SCANA had to give notice to floor's employees. Isn't that, in other words, SCANA, floor's employees are de facto employees of SCANA. Therefore, SCANA has to give them notice. That's your argument.
The argument is, of course, by giving the employees notice, fine, but if they give it to floor, what that accomplishes is that SCANA has done its duty, and now, of course, the employees are going to get notice from their proper employer. Yes, so SCANA owed the employees the duty, the obligation to get notice.
Well, you might have to rewrite the legislation to include it. That because it's the legislation and the DOL regs are written in terms of employer and employees in that relationship.
But 3 circuits have understood that the language is referring to the decision maker making it possible for the employees to get WARN notice. And if we didn't allow that to happen, then it will be liable, which is what happened here.
Counsel, we've given you some extra time here, and I think we understand your view. Thank you very much. Now, is Mr. Cole, do you have some rebuttal time? I think you have 1 minute.
Yes, thank you, Your Honor. I'm just going to quickly address 2 issues. One, the waiver issue. We clearly don't believe that we waived anything below. The court didn't think we did. If you read our opposition on page 23 to 25, in opposition to the motion for summary judgment, where we discuss Local 217, which is exactly the situation Mr. Ty is referring to, where a owner makes a decision to shut down a property, and the management company was found or could be found independently liable because they said there were ways they could have covered for themselves. So they were a WARN employer in an independent situation. Floor even replied to that in their reply brief, and Judge Childs ruled on it or put it in a footnote in her decision. As far as on appeal, it was on pages 20, 38, and 50 of our appellate brief, where we talked about Floor's prima facie liability. And on 23 and 24 of our reply brief, we cited Local 217 prohibiting contracting employee or parties from colluding to avoid WARN liability based on who ordered the shutdown. That was specifically in our papers at this level. So we don't believe we waived it. As far as the shutdown facts that Mr. Ty referenced, this is summary judgment. All inferences should be in our favor as the non-moving party. There was very little evidence put in about the process. There's no explanation as to why the notice that was given to the state, a single page notice, and the notice that was given to the FEI employees 10 days later. Again, why it took that long is one question, but why the 3 of them had Ms. Carty's name and phone number in it, whereas the one that was going to the 3,000 blue collar craft employees didn't have it in. So there's no explanation about that. There's no explanation or no evidence other than Ms. Carty's certification from all the witnesses that testified from Floor. Nobody explained the delays in getting the notice together. Nobody testified that they gave out any of the FAQs. There were several employee witnesses who said we never got the FAQ on the first day.
All right.
So,
thank you, sir.
Thank you.
We appreciate it.
Thank you, Your Honor.
All right. Has everyone concluded their arguments. We would like to thank all of you for coming, and we appreciate your arguments in what's a very interesting case. And I hope you will all have a nice afternoon.
Thank you, Your Honor.
We will
Your Honor.
adjourn court until tomorrow.
Thank you, Your Honor.
This honorable court stands adjourned. God save the United States and this honorable court.
Judges, I'm going to move you into the robing room now.
Yes, please.